Helps if I unmute myself. Kirsten, are you all set?
Yep, we're all set whenever you're ready.
Okay, then I will go ahead and convene the December 12th, 2023 meeting of the Injured Employee Partial Permanent Disability Payment Working Group. Any remarks from Rep. Conley?
Welcome everyone to the meeting. I look forward to our discussion.
Okay, thank you. First item then is approval of the minutes from November 28th. If I could have a motion. So move Rep. Conley, second.
Wait. I'm sorry, I was on mute. I sent over an email with some things that I saw when I reviewed the minutes.
Okay. Marie, when did you send that email?
This morning.
Okay, then that's good. I was tied up in the other meeting, so I didn't see it. Okay.
On page 5 and page 7 were the pages that I thought might be problematic.
Okay, let me get a second first, and then we'll discuss. Could I have a second? Brooke Foley. All right, discussion. Go ahead, Marie.
So on page 5, there were 3 things. One, in the second full paragraph that starts, Joseph Passaretti introduces himself. Third line down, it says he believes the proposed changes are and then it stops. So
yeah, I see that. Joe, do you remember what your thought was? The answer could be excellent idea or something else.
Overreach. I think it was overreach from my notes.
Okay, I saw. Let me just see. Sorry, I just sat down at my terminal. I'm pulling up the minutes now. I just want to be looking at what we're looking at. Okay. Minutes draft. We're on page 5.
Correct. Probably
Third
about
line down. My notes suggest that Joe said that the proposed changes were an overreach.
That's definitely a word that I would use. And since I think that, I can probably sign on to that premise.
Okay, so not excellent idea.
Well,
I'm just
those two, I'm not an elected official, Rep. Quinn, but those are not necessarily mutually exclusive.
okay. We'll amend the minutes to complete the sentence with are an overreach. Marie, what was your second?
Okay. Then if you, on the same page, if you go down to the paragraph in response, Bud Drapo states, there were 2 things on that. One, it says, however, he has not seen an instance where light duty was available to injured workers and the employers did not offer it to them, which resulted in a hearing. I find that hard to believe that Bud said that. I think he probably has seen.
Okay, Bud, would you be in agreement of eliminating the word not?
Yes.
Okay.
All right, same paragraph at the very bottom, it says available prior to national medical improvement. That should be probably maximum medical improvement.
I would agree with that.
And then on page 7, in the top paragraph, and this, I believe, let's say, in third line, first paragraph, third line, from the bottom of that paragraph, it starts, even so, she appreciates the proposal and believes that the workers' compensation system is unable to provide permanent injured individuals with the necessary skills. I wonder if that should be is able to. I think that was you, Chris, Representative Conley.
Okay, what page are we on then?
Page 7, it would be the second to last line of the first paragraph.
Bear with me for a minute. Medical. Okay, I'm sorry, Marie, can you say what you think the change should be again?
It says that you said that the workers' compensation system is unable to provide permanent injured individuals with the necessary skills. I don't have a note like I had with Joe's statement, but I find that
That's not what that's not what I said. Thank you for realizing that. I believe I wanted to, if we can adjust the minutes, that the workers' compensation, vocational rehabilitation would like to be more able. That I would like vocational rehabilitation to be more able to provide workers with the skills.
that's all that I have.
All right, repeat that one more time, Rep. Conley.
She hopes that vocational rehabilitation would be more able to provide workers with skills who are permanently disabled.
Okay. Instead of productive and tax-paying citizens.
We can keep that second part on it, but I think it's not that they're unable, we'd like them to be more able.
Okay. All right, so for purposes of our administrator, the changes that we're making are on page 5. It would be the 6th line or 3rd line in the second paragraph, adding the word overreach after the word and, so that the sentence now reads, he believes the proposed changes are an overreach. Again on page 5, going down to the second to last paragraph, which starts in response. Second line, however, he has seen an instance where light duty was available to injured workers. And then in the last line of that paragraph, changing the word national to maximum. And then on page 7, first paragraph, starting at the 3rd to last line, even so, she appreciates the proposal and believes that the workers' compensation system's vocational rehabilitation program would be more able to provide permanent injured individuals with the necessary skills in order to remain productive tax-paying citizens. I have those correct? All right, so with those changes, any other changes, corrections, additions, omissions?
Just one notation, Rep. Quinn, and I'm not even necessarily suggesting a change, but my name is mentioned 4 times in these minutes, and miraculously, the transcriptionist has managed to spell my name not only incorrectly, but incorrectly in a different way each of the 4 times. So just for future reference, my screen signature is the correct spelling of my name, if that helps.
I think I would have picked up on that, Joe.
All 4 times, it's not even uniformity.
My
All right.
note has been incorrect with 2 L's, but that happens.
Okay, then where Attorney Passaretti's name is mentioned in these minutes, if the spellings could all be changed to reflect Passaretti, that would be helpful. All right, with all of those changes and additions and corrections, if there's nothing else, all in favor of the minutes as amended, say aye.
Aye.
Opposed?
Aye.
Motion carries, minutes approved as amended. We'll move on to the next item, which is a continued discussion on the 31308 proposals. I know that we were hoping to get some comparative data. I know on my end, I don't have it yet. I don't know if anybody else was able to come up with any comparative data that they wish to share. Go ahead, Nate.
Yeah, I did a look at a number of states and basically there's 51 different jurisdictions of workers' comp in the United States, and it's very hard to draw a comparison. I mean, they all have the same type of benefits, total disability, partial, permanent partial, but they do things differently than Connecticut. We do things differently than them, and it's really hard to draw a comparison. The only thing that I saw in common is the max comp rates are pretty close to the same. They all have widows benefits. They all have funeral expenses. They all have vocational rehab programs, but in terms of calculating things and every state does things differently with their permanencies. Everything. The one trend that I did see is that every state in general has a way to extend benefits for longer periods of time than Connecticut. Connecticut, you're totally disabled, you're partially disabled, you get your permanency and your 308A, and unless you're pushing for lifetime benefits, whether it be a statutory permanent total or under an Osterlin, the Connecticut benefits just seem to end, and where they end is, from what I could gather, is less than what the other states have. But other than that, there's no correlation I see that would drive a business out of Connecticut to go to these other states. For example, in Massachusetts, there's open medicals. You can't close medicals in Massachusetts. In New York, they allow for workers' comp benefits to be paid for injuries that don't happen at work, but if you're on unemployment, say, or if you're out on FMLA. So they vary all over the place. So that was my analysis based on the information that Jim was able to, I guess, to provide to the group that was sent to Marie Gallahall, and ultimately that was provided to the group. So I don't know if anyone else did any analysis, but that's what I came up with. Sure.
Okay. Thank you, Nate. Brooke?
Thank you. Good afternoon, everyone, and thank you, Representative Quinn. I apologize because apparently my computer connection is unstable. So if I go out for some reason, I just wanted to let you know because it's kind of sketchy right now, in and out. But I was able to pull together some information. I'm wondering if it's possible for me to share my screen.
I don't see why not. So go ahead unless there's something that I need to do on this end.
We all set now.
Okay, go ahead, Brooke.
Okay. Can you see my Microsoft Excel here?
Yes.
Okay, so I did find some information on the Social Security Administration webpage. And I would agree with Nate that it's extremely difficult to compare states, but there is some data that I think is worth mentioning. First of all, I looked at all of the states' maximum weekly workers' comp payment amount, and it's not directly the PPD, but as you can see here, I have all of the states and I sorted them by max amount per week. And if you can tell here, this stuff at the top takes the top 4 lines, and Connecticut is 14. So actually, out of the 50 states and DC, we're number 10. So the max is 1575, and as you can tell, it's number 10 if you don't count these top 4 lines. And then I looked closer just at New England, and this is the max weekly workers' comp payment amount for effective August 22nd. And Connecticut is the 4th highest out of this region. I included New England, Pennsylvania, New York, New Jersey, and you can see we're like right in the middle of those states. And I'm happy to send you this data. This is all available on the Social Security Administration webpage. Then I have the base compensation rate, and this was very difficult to, parse out. So I just basically stuck to the Social Security Administration, but also if you can see over here on the right, I have each state's website where it goes to information on the workers' comp data for each state. And this is the base compensation rate for each state. And as you can see, Connecticut, 75% of the after-tax average weekly wage. And this is different a little bit, for each state. The language is a little bit different, but you can see that Connecticut is very generous for the base compensation rate. And again, I just looked at the region for these. And then for PPD max weeks, I have the region, and then this, I didn't look at every state, but I looked at the region here. And I included the website, so you can look on these websites to see exactly, the source of where I'm getting this information. And for some of them, like New York, it doesn't have it here because for some of the states, I wasn't able to get a specific amount of weeks for PPD. And then I also looked at cervical spine, and this was, very difficult for me to figure out, being that I'm not a practitioner in this area and every state does things differently. And so this is just the states in this region. You can see that some of them base their calculation on different guidelines and whole person impairment, and not necessarily a schedule the way Connecticut does it. So it's hard to compare, but I'm happy to send this information. But basically what you can see from this information is, in our view, that, it's not, Connecticut is not necessarily insufficient. Like, we're pretty generous compared to the other states in the region.
Going to your second page, or probably the third page, go to the next screen.
This is base compensation rate?
Yeah. New Jersey, New York, Pennsylvania, and Rhode Island, and also Maine. It seems that it's, 70%. It ranges from 60% to 70%. But I interpret how you have it written as that is off of the gross and not the net, correct?
I think I just copied it from however the state reported it. So
just pointing out that with New Hampshire and Connecticut, it's an after-tax average weekly wage, so the net. But it looks like with the other states that it's a percentage of the gross, which in some instances could be a higher number.
Sure.
Okay. All right. I just wanted to make sure I was reading that correctly. And then Vermont apparently has come up with some new calculation method.
Yes, and it was difficult for me to figure that out. So I wasn't able to actually include that here, but like I said, I'm happy to send this to everybody so you can look at the page for the individual states.
Yeah, if you want to send it to me, we'll get it out to the group. Absolutely. Sure. And appreciate your effort in doing that.
Sure. Did you want me to stop sharing, or?
Is everybody good with the information, or do you want to keep it up?
Oh,
All right, why don't you take it down for the time being and we can have you put it back up if
Sure.
necessary. Why don't we start out with any comments or questions on that information? Go ahead, Bud.
Yeah, I just wanted to point out that the maximum rate that was shown for Connecticut is for temporary total benefits, I believe, and not the benefits we are discussing here. That the if I can just check here, the max rate for the benefits we are discussing here is actually $1,154 a week, and not the $1,575. I just wanted to point out that distinction.
Okay, thank you. Okay, anyone else with questions or comments on what Brooke just shared? Okay. Why don't we then, thank you, Brooke. Why don't we then move back to the proposal that Bud and Nate had put forward? And why don't we start with the cervical, which was a change from the 117 weeks to the 374 weeks. What are your thoughts on this? I mean, in general, I'm in agreement on increasing what we do for the number of weeks on the cervical spine. For me personally, I'm not sure if that higher number should be the back or should be the shoulder, because oftentimes there's interplay between the two body parts. I mean, I see it, at least in my experience, it seems to have been more of an interplay between the neck and the shoulder. And, I'm hoping that the doctor opts to rate the shoulder just because it's a higher number of potential weeks of compensation. But from my friends who are practitioners on both sides, what are your thoughts here? Go ahead, Rep. Conley.
I think the 117 is low, and I would note that there was a Scrivener's error in 1993, so I don't believe it was the intent for the neck to be 117. I believe it was the intent in 1993 was for a higher number. And note that the changes in 1993 were in the good old implementer, so that issue of workers' compensation, cervical spine rating was not discussed by the legislature when the implementer came out in the wee hours of the night that year. I know that maybe not folks or these folks, I wouldn't speak for anyone on this Zoom call, but I have heard from many respondents and claimant lawyers that the 117 is low. And a lot of folks have said not officially to me, since we've had this working group, that they would see it to be appropriate to raise that issue, to raise the 117.
Okay.
Was that a vote in favor of changing lumbar to 347?
No, Joe, that was not. I understand that there might have been a Scrivener there in lumbar as well, but we're talking about the neck PPD right now, the 117.
Yeah, go ahead. What are your thoughts, folks? I mean, go ahead, Bud.
Yeah, just by way of context, as many of you may not know, the neck had been, I believe, 175 weeks prior to 93. And if I'm wrong with that number, somebody please correct me, but I believe it was 175 prior to 93.
That's correct.
should that be the number then that we propose now? Or should it be a different number?
I think it should be somewhere in between. If it should be higher than 117, but if the lumbar is at 374, that should be the ceiling of it. And I suppose that you could find a number in between, split it, or that's one way to approach it. Another way that was kicked about originally when Bud and I were going over this is just go back to the pre-93 at 175. That would be a way. I will say this is that very few of the states I looked at had specific awards the way Connecticut does. We may include more body parts, but the body parts that the other states have are much higher than ours. For example, in New York, they don't go master arm or non-master arm. They just have 312 weeks. And we use 208 and 194 respectively between master and non-master. So I think that the increasing it does make sense, but I think it should be somewhere in between there where we as a group can come to a consensus on. And again, how you want to do it, you want to split it in half. Is there a reason to perhaps come up with something more akin to the closer to the max rate on the max number of weeks, say on the shoulder? We seem to fall in on that 208 rate. I'm willing to consider anything that makes sense. But leaving it there doesn't make sense. Maybe the analog of moving it to 374 for some people doesn't make sense. But given those parameters, we should be able to find something in between that does make sense. If 174 made sense prior to 93, why should it make less sense now? I'll just ask that rhetorically. So,
Yeah, go ahead, Joe.
I just want to make a comment about New York. I don't want to go down the rabbit hole, and I'm not a New York expert, but I do know a little something about permanency in New York. And the fact of the matter is that's an elusive figure, because under New York workers' comp, your permanency is assessed on the basis of the 312 weeks, but less all benefits received from date of accident. So if you theoretically got a 10% of impairment entitling you to 31.2 weeks, but you were disabled as a result of a surgery for 52 weeks, then your permanency award is 0. So it's really not comparable. And in fact, New York is one of the least forgiving in terms of permanent partial disability and supplemental benefits. It's one of the most forgiving in terms of TT and TP, because people stay on it forever because of that dynamic. But I don't think it's a good I don't think it's a good frame of comparison.
well, that's right. There is no, as I said, these things don't mesh easy. The flip side of that is New York does, the neck would not be included in the specific schedules in New York. It'd be under the non-specific, where a judge or how their administrative hearing officers could award up to, I think it's 525 weeks. And so there's a lot of variations on that. But in Connecticut, we deal with these, as I said, we have a laundry list of body parts, and we assign specific weeks to them. And so we don't want to get into this range, but at least I don't think we do. But to the extent that we're going to increase the neck, I think it should be greater than 117.
Well, just to follow the logic that you just espoused, I will just add that what we know for sure is that in 1993, the legislature rejected 175. Whether or not that's the moray of today, it's been 117 for as long as it has been. So if you're talking about a compromise, and I'm not suggesting that this is the compromise, that the compromise should really be somewhere between what the legislature has already rejected and what the current number is now. Just making that observation, that number would be 146. It might be something to consider in terms of where between now and then we land.
I read that a little differently, Joe. There's no legislative history on what they did or didn't do in 93. Prior to that, there was the neck was considered, I think, an unscheduled body part, which I think one of the commissioners at the time might have been Arcudi, might have been Fox, it might have been someone else, but they came up with a number of body parts for a number of weeks of some of those non-schedules. But overall, yeah, what they did is they rejected the entire permanency scheme in terms of the number of weeks by doing a slash of a 1/3 reduction. So
That's right, and that's the point I was trying to make. I don't think that there's any clear intent on it as regards any particular body part, but I think the clear legislative intent was to reduce all benefits by 1/3.
that's the only thing you can gather, because that's what they did. That's what they did, and eliminated eliminated emotional claims unless they're tied to specifics and things like that. So
Go ahead, Bud.
Yeah, without getting too lost in technical discussion, just in terms of focusing on recommendations that would likely to turn into action, would it be easier if we use the word restore? If we were restoring the 175, is that something that is more palatable and more likely to result in legislative action?
You know, that might be because at least we can point to how it was and use that as an argument for why it should be that again. And it is a smaller increase that may be more palatable. What do folks on the respondent side think about that?
I would just raise the probably more obvious concern that, does restoration mean restoration to just one body part that you've pinpointed, or is this some sort of a cascading event to restore the 93 changes which were made for specific reasons? That would be my concern.
Okay. Anybody else with thoughts on that? Go ahead, Representative Ackert.
Thank you, Representative Quinn. I appreciate it. Yeah, this is the dialogue that we've been taking place for the last couple of weeks, is that this has got to be presented to us in the legislature. And the question we'll ask is, well, where did that number come from? Well, it was a happy medium from what it was in 93 and today. It's not going to be a solid, approach. Some case history, things like that will really be of value to us, so and Rep. Quinn and Rep. Connolly, I always, look forward to your and Senator Kushner, thoughts on this too, is that, it's got to be presented to us. Why did it change in 93? Why is it, what are we going back for? What is the validity of, this piece of, I think that discussion would be very, very helpful. So having some background when that question's asked, that we can have a reasonable approach to voting on this. So thank you.
Thank you. Anyone else with some thoughts? Senator Kushner?
Here, I was trying to find my hand. And I am in agreement with Representative Ackert insofar as having some, specific references for us would be helpful for those of us who were not around or practicing. Some of you may not have been in the legislature in 93, but I know there's some people on here who were practicing then. And you know, I also am fully aware that there were things that were done in 93 that we are now changing because I believe the history of 93 may have been driven primarily about cost savings and not necessarily about what was right and just for workers that were injured on the job. And so, you know, I think as a legislature in recent years, we have looked at making changes that would help workers, particularly around the PTSD was the, you know, the main major changes that we made. But I would appreciate hearing from some of you who were practicing at the time, or if we could get some some opinions from folks that were in the legislature at the time, that would be helpful as well. Thank you.
Thank you. Did, and I don't have any clients that have got an injury that old, but did they grandfather in pre-1993 neck injuries such that those permanency ratings were based off of the 175 instead of the 117? Marie?
What I can tell you is the date of injury rule, Representative Quinn. So if you had a 1989 date of loss, you get paid. And even today, if you have an increase in permanency today from an injury that occurred in 1989, you get paid that increased permanency based on the number of weeks that were in effect in 1988.
So I would gather then that the reverse would be true, that if we do increase this number, that pre whatever date that happens, injury would be locked into the 117 as opposed to a higher number, correct? Okay.
Yes, yes. I have a few of these older cases still kicking around, and we do just pull out the old book and use the whatever body part is. I always have to look it up because I'm never sure what changed and what didn't change.
Okay. No, thank you. I appreciate that.
Marie's got the old book, a little probably sticky on it, so she can go to the old book. And it's thin. If we note, it's about like 60 pages.
Well, it's a pocket part.
Yeah.
Yeah,
Right.
just a word about retroactivity. I think we want, in my opinion, to stick to the date of injury rule simply because in as much as we, you know, the legislature can do whatever they want in terms of intent of retroactivity, but almost invariably when you see a benefit being reinstated or changed retroactively, that gets coupled with the retroactive benefits becoming the responsibility of the second injury fund because of ex post facto constitutional concerns, which if you do that, you die in economic impact to the state.
All right. So what is everybody's thought then of returning to the 175? I mean, is that a reasonable compromise? And thinking from a legislator standpoint, is it rectifying, you know, what is perceived to have possibly been a Scrivener's error, and is that sufficient enough to satisfy some legislators that that's why we're doing this? Or you know, do we think that we're putting in too much of a financial burden by changing it to anything over 117?
Repcon, I think it's important to put something in, and then when things go to committee, then OFA could always weigh in, and we don't have to guess about what the cost would be prospectively in the future. The committee would have that information and be able to weigh that information in session.
Okay. All right. So, you know, can we get a consensus then on the 175? I mean, is there anybody who, you know, just adamantly thinks that changing to 175 is a bad idea, either because it's too high or too low?
It's actually, I have a comment, and it sort of tracks what Colette was talking about, and that is, I don't think I'm alone in the concern. I think you will have legislators who share the same concern, which is if we're talking about taking one body part and putting it back to pre-1993 levels, are we in fact accomplishing the imprimatur of this committee in identifying particular areas of insufficiency? Or is this a harbinger to, okay, we got the cervical spine, so now let's work on the rest? To me, and again, I'm not necessarily saying I'm in favor of the 175, but I'd be a lot more inclined to be if the recommendations of this committee that came with that proposed increase also came with a determination that we've looked at the other scheduled body parts and determined that they were sufficient.
Were there other body parts that were reduced as part of the 1993 changes?
Scarring was reduced
Okay.
significantly.
They were all reduced. It was
The
across the
scarring
board.
was practically eliminated, Colette. Practically
Well,
eliminated.
I think the question, Nate, as I understood it, was, were there other body parts whose permanency benefits were reduced? And indeed, there was a 1/3 reduction, except for the lumbar spine, which we've already determined was a Scrivener's error. It should have been 347, it's 374. But there was a across the board 1/3 reduction in the permanent impairment benefits for each of the scheduled body parts. And yes, they did away with unscheduled body parts, but they added many of those body parts as now scheduled body parts. And in the cervical spine, utilized the 175 weeks that was being used out in the day-to-day comp offices as the cervical spine, and then reduce that by the same 1/3.
Right.
I'm not sure, Rep. Conley, about the Scrivener's error on the cervical. I always understood it to have been simply a 1/3 reduction on something that was being used on a regular basis in the comp offices. And so that was my concern with saying we're going to go back to the way it was, is, essentially what I, the first question I would have is, well, then are we going to go back to the way it was on every single body part, which clearly is not the intent, I don't believe. So to me, that was my concern about saying to rectify something that was. I think we're looking to look ahead to say, is there something that can be done that would bridge whatever perceived gap, but without going back to looking at every single benefit.
Yeah, and also I'm not crazy about using 93 as the benchmark, because on the other side of the coin, if we use 93 as a benchmark, then we're back to unlimited 308A, because that was what was done prior to 1993, which on the claimant side, I don't think any of us would necessarily object to, but recognizing that limitations were put in place, and at least my feeling that particular limitation was probably too far, but going back to the way it was and having it being unlimited is absolutely going too far. So I throw that out as well, and maybe coming up with a new number is the way to go. And I'm not necessarily saying that should be above or beneath 175, but again, thoughts on that, because 93 can be a benefit and a detriment depending on which benefit you're talking about.
The only thing I would add there, and thank you, you know, Joe a little while ago, and this is not, saying this is what it should be, but coming up with the compromise between the 117 and 175, because I think we have to recognize that there was an intention in 93 to reduce the benefits, and for multiple reasons, but in recognition of that, I think just simply using the 175 takes away from the purpose of those decision-making process that went into 1993.
Thank you, Colette. Anyone else have some thoughts on this?
Yeah, I would just bring up again what Senator Kushner said about the PTSI, which I think was such a good point, that there was an intent to get rid of PTSI in 93 in the General Assembly over the course of 3 separate bills over the last, I think, 4 or 5 years, brought those claims back in a different way, to show that so there is legislative history that the 93 changes were not by the legislature entirely permanent, and that the good thoughtful thinking as to appropriate benefits did occur afterwards. So while I'm not against a number different than 175, I think there is definite legislative history that the 1993 changes have been revisited in other issues of that law.
Okay.
Here's
go
an
ahead,
idea.
Nate.
If people are really stuck on not going back to pre-93, 175, because maybe we can find that justification way back in some treatises somewhere where they came up with that. And if they don't want to go back with that and you stay with the schedule, then why don't you just allow, and I know some members on this committee may not agree with this, why not allow the judges to have the discretion to award more in the right case with the right set of circumstances, up to a certain amount, like they do in some of these other states, whether it be Massachusetts or New York. Why not consider that as a possibility? I'm not saying that that's something I subscribe to, but it keeps in place the ratings, and I want to see these ratings increase. I really do. And that's my first position. But if you stay with these ratings, you have to find a mechanism that's going to allow, in the right cases, to go forward with additional benefits. And right now, our statute doesn't allow that. It's very inflexible. And it's either you just get what's there or it ends, or you go to trial on an Osterlin matter. And the thought is that if there was this added discretion from other commissioners that would have to be articulated, it would benefit, it would inure to the benefit of the injured worker in the right case. It would benefit the employer because it wouldn't be every case. Maybe a lot of cases, but it's not every case. And it would inure to the commission because then they'd be fashioning remedies without these long, expensive trials too. It's a possibility to consider that approach.
Colette, were you motioning to respond?
I'm sorry, I was not, but
Typing something else? No problem. Go ahead. Or not.
yeah, no, I mean, the only thing I would say, which I think has been said before, the problem, frankly, with discretion is we end up with litigation. And, what would be the parameters of, who gets more? I think having a certain number of weeks and having the medical community weigh in on the percentage of impairment, which is a medical determination. I think that discretion will only lead to additional chaotic hearings and not necessarily, frankly, good for the injured worker.
Colette, can I, and I agree that it could do that. But in those areas where they do exercise discretion, 308A, I mean, how many trials a year do you have on 308A? And there's a limited. We go there, we find a compromise. Sometimes we're too far apart. Commissioner says what they think it is, and we end up coming to an agreement. Discretion with the limited scarring that we do have. How often do those get litigated? So yeah, I guess it could lead to more litigation, but it could also foster the opportunity to compromise. If you knew that you were at 117, or I'm just going to throw this out there, that 208 number, because you see that with the scarring. If you knew that it could be somewhere in between there and the right set of facts, wouldn't the parties find a way to work out an agreement in that situation? I would think they would. I certainly would. So, what do you think, Colette?
Before 308A was as it is today, I think there was much more litigation when it was discretionary and there were unlimited benefits. I would venture to guess, and I've not counted, that there were many, many more cases that went to formal proceedings on 308A. And yes, is compromise something we do? Yes, but I also think that it leaves it open for far too much difference between various cases. So that's my feeling.
Okay.
Go ahead, Joe.
Thank you. Now, the phrase Nathan used earlier, it's been come up a couple of times during this and other meetings, is Osterlin. And for those who are not practitioners, just so we understand what we're talking about, the Osterlin versus State of Connecticut is a Supreme Court case that allows for determination based on vocational evidence on a totality of the circumstances basis that takes somebody who on a Department of Labor statistics basis, it may be sedentary duty, but is in effect unemployable for purposes of any real practicality, and allows for someone to be considered totally disabled, even though they may have a sedentary work capacity. Things like age, education, transferable skills, country of origin, English as a second language are all factored into that. The thing, though, is that when you bring up the Osterlin case and the availability of a functional permanent total disability, it ties together with this notion that 308A is insufficient. In fact, it's not, because when 308A runs out, the fallacy is that, well, there's nothing else for this person. The reality is that you can pursue an Osterlin claim. Now, the immediate counter to that is going to be that's extraordinarily expensive. For a claimant to prove a vocational total disability under Osterlin, then it winds up costing upwards of $5,000 to $10,000 in expert fees, and that can be burdensome. But that can be fixed quite simply without any amendment to 31308A by just amending 31300 so that a claimant's costs in pursuit of a finding of Osterlin, much like under 31300, their medical expert testimony gets paid for by the unsuccessful respondent, that their vocational expert testimony be paid for by the respondent in a case where they lost. In other words, the real problem with Osterlin in going beyond 308A is how much it costs to do that. You can fix that and not change anything about 308A.
All right, thanks, Joe. Anything else on the neck? All right, then let's move on to the skin. Thoughts on changing from 0 to 208 weeks minus any scar disfigurement award?
Just to remind people, the premise of including this is, I think Bud made the point at our second meeting that the skin is the largest organ in the body, and it's not even covered under the it's not specifically covered in the 308B where all the other permanency ratings are. And the thought is that if a permanency was to be paid on this, it should be a range. There's a number of other permanencies that seem to have ranges in them within our statute. So this would be, we find a range in there that the judge could award, but if there was also a disfigurement paid on that, they could be less that too. So it wouldn't just be considered, one of the proverbial double recovery. It would just be an additional amount, less whatever permanency was paid on it. And the 208 part came up because that's the maximum amount that can be awarded for a disfigurement. And so that was the genesis of why we included the skin here.
Well, Quinn, do we want to put on record what you can and cannot get benefits for? Because I think a lot of us on the call know, but I don't think record is aware what the 93 change was.
Well, prior to 93, I think there was this catch-all that judges could award any body part that wasn't listed, and obviously those that weren't in that nifty list that they created for the unschedules didn't get incorporated. That sort of catch-all, necessary and proper discretion of the commissioners dropped out in 93. So things like this just got swept away, sort of in the 93 tidal wave of reforms. So.
And the scarring, Nate, do you want to, for the record, just say what after 93 folks can get for scarring?
So after 93, you really can't get a reference. You can't get an impairment rating to the skin. And you might be if you can show that it's limited to, it causes unemployability. You might be able to get a disfigurement that way. And of course, disfigurement is just limited to, I think, the face and the head and any other body part, but you have to connect it specifically to that it impacts your earning capacity, which is unlike any other permanency which is awarded in Connecticut, which you don't have to connect to any earning capacity. It's not based on loss of earning capacity. It's based on loss of function and usage. So the thought was to include the skin in there too, to the extent that a doctor could provide an impairment rating to that. And the commissioner the judge would have discretion, unless he wanted to come up with a specific number of weeks, which I think should be 208. But the judge would have just, if he didn't have that, then there would be a range where the judge could exercise her discretion. The legislatures appoint these judges to exercise discretion. And I get from what Joe and Colette are saying about, if you set a ceiling, they're always going to gravitate to that ceiling. But there are checks and balances that can be put on those discretions. But I don't think we should be so afraid of giving these judges discretions to use. I really don't. So more than happy to discuss something that would lead towards a specific rating for the skin.
Go ahead, Bud.
The situation where this comes up frequently is when someone gets a severe burn that's not on their face, head, or neck, usually the torso or the legs. It can be a chemical burn or a fire burn. And really, there's not a lot of compensation available to those individuals. There's no longer scarring unless it's the face, head, or neck. And if the scar doesn't impact a scheduled body part, the function of a scheduled body part, there's really nothing they're left with horrible disfigurement and really nothing available to them in terms of benefits. So these are the individuals I have in mind when we're talking about the skin.
Thanks, Bud.
If I could add
ahead.
something that I think of with the new technology and the cervical fusions, we've seen a lot more of the cervical fusions in the front. And if one gets a keloid scar due to their skin complexion or skin makeup in the front from a cervical fusion, that is a very disfiguring scar that folks are left with right in the front of their neck. A big hangman's type scar. Some folks do have quite a disfigurement that they are portraying to the public on a daily basis.
Okay. Thank you. All right. Anything else on skin?
Yeah, the
Go
thing,
ahead, Joe.
the thing about the skin is, you know, the Supreme Court dealt with this very issue in a series of cases called Barton versus Ducci, went back and forth a couple of times. And the fact of the matter is that the Supreme Court took it upon themselves to interpret the statute as relates to the particular issue in question, that being an individual who was badly burned and had no available benefit under 31308B. But what the Supreme Court concluded in that case is that this individual did have rights to compensation under 31-308B, but rather than as a skin award that is not scheduled, but that the doctors, clinicians who were caring for him just needed to express that disability in terms of a rateable body part. Now that may seem elusive, but if a severe burn is impairing the functionality of your leg, then you can get, and that's 2 ratings right there. Of your arm, that's 2 more ratings. So now there's 4 ratings. And the idea is there is a way for someone with bad burns, not in the face, head, or neck, to be available for compensation. And that's directly from the Supreme Court. That's not me theorizing. So on the subject of, are there benefits sufficient in this area, the Supreme Court has provided that formula.
Thanks, Joe. Anyone else on skin? All right, then we'll move on to the hands. Any comments on the hands? All right, then we'll move on to the catch-all for the unlisted body parts. Comments on the catch-all?
I see this approach as the way to go to really handle either those body parts such as the skin that aren't included, or if a judge finds a specific permanency paid is inadequate for whatever reason. They're in rehab, they're retraining, maybe they're too old for retraining, but they're trying to look for work in some of the way, shape, or form. I think or the AMA guidelines that are used maybe are inadequate for whatever reason. I think judges should have this discretion to award something above and beyond the permanency that they have. And you say, well, that's 308A. Okay, well, they give them more 308A. But I see this provision as a way to solve a lot of the problems that we're talking about in terms of either not giving away the store or inadequacy of benefits. And I think what you do is you have specific parameters that the judge has to articulate to go beyond the permanency, or even into 308A, to go beyond the number of weeks of the 308A. And you have a limitation in terms of the number of weeks. I put 520 because that seems to be the top number in the statute, but it could be whatever the legislature decides on that. And so I really see this as a win for everyone, because it allows a remedy to be fashioned that works with the injured worker. It allows predictability in the sense of a judge has to articulate why they're doing it. And it also allows for the parties to negotiate something different. Maybe the judge would award more, maybe the judge would award less, but the parties would come up with their own agreement on this too. And I think that it would foster a lot of maybe discussions on it, but I think it would also foster a lot of resolutions too. And I'd really like to see this back in our statute.
Other comments, concerns, questions?
Yeah,
Right.
I do have to
Go
say,
ahead, Joe.
and the minutes of our meeting are going to be riddled with things about my aversion to discretion. So I'll say, and I think I'm on record already, but I will say this: I don't think it's true necessarily that the legislature always wants our judges to exercise unbridled discretion. Case in point, sentencing guidelines. There's a reason why our legislative process creates sentencing guidelines. It's because judges across the state lines, who all come from different areas of influence, education, experience, can and will exercise diverse ranges of discretion outside the controlled parameters that the legislature's expectations may be. And you know, I would be remiss if I did not point out to my peril that the qualifications and experiential preconditions that lead to becoming a workers' compensation judge are not uniform. So the idea of giving unchecked discretion, which, by the way, at the appellate level, the standard of review is abuse of discretion, which I dare say is impossible to prove. So adding unchecked discretion to the hands of both the seasoned and experienced workers' compensation judge and the brand new workers' compensation judge who may not have set a foot in the courtroom one time in their life is just too dangerous. And I'm not saying this just as a respondent who is in the position of losing those cases every single time. But the economic impact to the state, both in actuality and in theory, and by theory, I mean what happens to, sorry to pick on you, Nathan, to all of Attorney Schaffner's settlement demands when there's this discretionary benefit out there that he could theoretically have. Those numbers have an impact on insurability, and those insurability numbers have an impact on premiums. And when those premiums go up, then employers leave.
Go ahead, Bud.
Unlike the discretion we were discussing in 308A, which would apply in hundreds, if not thousands of cases, the discretion here only addresses cases that where the body part is not listed as a scheduled body part. So I think we would be talking about relatively few cases where the discretion would come into play. A case where it involves the intestines or something that's not scheduled. So I don't think the concern about discretion is the same in this instance as it would be in, say, unlimited 308A.
Okay. Yeah, thank you. Anyone else? All right, then let's move on to the extended 308A benefits. And what was put into the proposal was that that the injured worker would have to be enrolled with workers' rehab services. 2, if they're doing job searches, they should be paid at the full base rate. It would eliminate the prohibition on out-of-state claimants collecting it, if I'm reading that correctly, and then cap it at 208 weeks or the PPD weeks, whichever is greater. Comments, questions, concerns on that? Okay. All right, well, where we are at the moment is we have had a proposal put forward. I would welcome anyone to come up with an alternative proposal. And once we have had that opportunity, then I think that we can get to a point of making recommendations on changes that we'd like to see the legislature attempt to make in our next session. So any other comments, questions, concerns at this point? All right, then. Anything else? Oh, next meeting, we had this discussion in our records group. Our next meeting would be slated for December 26th. I know Joe is very anxious to have us meet on December 26th, but I think other people may feel differently. What we did with the other group is we went to January 2nd. Would that work for everyone here, or most of you? Okay. All right, then our next meeting will be on January 2nd at noon. If there's nothing else at this point, I would like to wish everyone happy holidays and a happy new year, and we'll see you on January 2nd, 2024. And if I could have a motion to adjourn. Rep. Conley, second.
A second.
Colette, all in favor?
Aye.
Opposed? Motion carries. And again, thank you, everyone, and we'll see you back here on January 2nd.
Happy holidays.